Good evening, everyone. I'm Lorraine Nolan, member of the Board of Directors of WDI USA. The fight to preserve the sex-based rights of women and girls is intense, and we can get pretty discouraged at times. I know I do. But Kara Dansky, the president of Women's Declaration International USA, will show us that we are a lot further along on the path to victory than we think. Kara Dansky.
Thanks so much, Lorraine, and hi, everyone, and welcome. So this is a talk that I initially gave during the Feminist Question Time on July 1st of this year. I wrote this talk intending it to be for an international audience, but I also wanted to share it with our US-based audience because I think it has a lot to say about where we are in the fight to liberate women and girls from gender identity. I hope you enjoy it. When I did it on Feminist Question Time, I really had to rush through it. I went very quickly, but I think I can take a little more time with all of us here tonight. And then I really look forward to a discussion afterwards. So thanks so much for coming. Lorraine, can you go ahead and share the slides? Great. So I was there at FQT to talk about updates in the US, or as I prefer to call it, why I think we're much further along in the movement to liberate women and girls from gender identity than it might appear. I think the easiest way to understand this is to start with the basics of how the government is organized and then go through all the strides we think we're making in each of them. Could we have the next slide, please? So this is basically how our government is arranged. We've got the administration under the president, the legislature, which is Congress, consisting of the House of Representatives and the Senate, and the Judiciary, the Supreme Court, and all courts underneath them. Underneath all of that, we have 50 state governments plus Washington, D.C. And I assume that most countries are organized similarly at the national level and that every country has some form of state or provincial government organization. So, as most of us know, it's the US Democrats and the political left that is largely driving the gender identity train here. That's absolutely true at the federal level, and it's only slightly less true at the state level. It's mainly the Biden administration, the Democrats in Congress, and the Democrats in the states who are making life miserable for women and girls throughout the US. I say this, of course, as a lifelong Democrat and a leftist myself. The courts are supposed to remain apolitical. What I want to do here is explain what's been going on in all three branches of the US government and in the states, and why I think we're making more progress than might be obvious. Can I have the next slide, please? Starting with the administration. On January 20th, 2021, on the very first day of taking office, President Biden issued Executive Order 13988 on preventing and combating discrimination on the basis of gender identity or sexual orientation. The executive order begins with this policy statement. Can I have the next slide, please? Quote, every person should be treated with respect and dignity and should be able to live without fear, no matter who they are or whom they love. Children should be able to learn without worrying about whether they will be denied access to the restroom, the locker room, or school sports. Adults should be able to earn a living and pursue a vocation, knowing that they will not be fired, demoted, or mistreated because of whom they go home to, or because how they dress does not conform to sex-based stereotypes. People should be able to access healthcare and secure a roof over their heads without being subjected to sex discrimination. All persons should receive equal treatment under the law, no matter their gender identity or sexual orientation. Now, this statement is, in my view, in some ways completely straightforward and in some ways really annoying. The statements, quote, every person should be treated with respect and dignity and should be able to live without fear, no matter who they are or whom they love. And quote, children should be able to learn without worrying about whether they will be denied access to the restroom, the locker room, or school sports seem entirely innocuous. Probably everyone agrees with those statements. I highlight two phrases in the policy statement here. Quote, because how they dress does not conform to sex-based stereotypes, and quote, gender identity. Now, I think probably everyone agrees with the statement, quote, adults should be able to earn a living and pursue a vocation, knowing that they will not be fired, demoted, or mistreated because of whom they go home to, or because how they dress does not conform to sex-based stereotypes. In fact, this is already settled law. The Supreme Court already said this in a case called Price Waterhouse versus Hopkins back in 1989. In that case, a woman named Ann Hopkins was discriminated against at work because she refused to conform to her male colleagues' expectations of femininity. And the Supreme Court rightly decided that was illegal. In other words, this is already settled law, and this aspect of the policy statement was totally unnecessary. But the other thing that's interesting is that the order does not define the words gender identity at all, other than this oblique reference to nonconformity with sex stereotypes. If gender identity means nonconformity with sex stereotypes, we can all relax and go home. Most people don't care if people deviate from sex stereotypes. But as we have learned, that's not at all what this is about. The order continues. Can I have the next slide, please? These principles are reflected in the Constitution, which promises equal protection of the laws. These principles are also enshrined in our nation's anti-discrimination laws, among them Title VII of the Civil Rights Act of 1964. In Bostock versus Clayton County, the Supreme Court held that Title VII's prohibition on discrimination because of sex covers discrimination on the basis of gender identity and sexual orientation. Under Bostock's reasoning, laws that prohibit sex discrimination, including Title IX of the Education Amendments of 1972, the Fair Housing Act, and Section 412 of the Immigration and Nationality Act, along with their respective implementing regulations, prohibit discrimination on the basis of gender identity or sexual orientation, so long as the laws do not contain sufficient indications to the contrary. Now, in order to understand what the administration was doing here, you have to know a little bit about Bostock. That case was originally 3 separate cases. 2 of the cases involved gay men who had been fired from their jobs because of their sexual orientation. The 3rd case involved a man named Amy Stevens, who had been fired from his job because he claimed to be a woman. The 3 cases got joined together, and the Supreme Court eventually ruled that employers can't discriminate against employees on the basis of either sexual orientation or transgender status. Now, to be clear, I hate the Bostock decision in large part because in deciding that people can't be fired because of their transgender status, the Supreme Court said nothing about what transgender status means, not a word. The court simply assumed that transgender status is a coherent descriptor of a person. But as much as I hate the Bostock decision, what I hate even more is what the Biden administration said about it in this executive order. It said that the Bostock decision means that no one is allowed to discriminate against people on the basis of gender identity. The Bostock decision literally did not do this. I've read the decision countless times, searching for some place where the Supreme Court might have done this. It didn't. In fact, the Supreme Court doesn't even mention the words gender identity, other than in a single footnote citing an outside source. The other thing that's really annoying about this order is its extension of the Bostock decision outside of the employment context. In the decision itself, the Supreme Court expressly stated that its ruling was limited exclusively to the employment context. So when the Biden administration says that the Bostock decision prohibits discrimination on the basis of gender identity and that its reasoning applies outside the employment context, it is simply lying. The order then went on to require US federal agencies to review all of their policies that pertain to sex and to rewrite them to prohibit discrimination on the basis of gender identity. Sadly, throughout the first 6 months of 2021, federal agencies went on to do just that. The US Departments of Justice, Education, Housing and Urban Development, Health and Human Services, and others all went on to issue various memos and guidance documents that shredded the material reality of sex for purposes of federal administrative law. I'll explain the status of those memos, various memos and guidance documents when I get to the part about the judiciary. But for now, I want to say one thing about why I think all hope is not lost for women and girls with respect to federal administrative law, notwithstanding this horrific executive order from 2021. In June 2022, the Department of Education issued a proposed rule regarding Title IX, which concerns discrimination against women and girls in education, including sports. The June 2022 proposed rule would have, consistent with this executive order, completely redefined sex to include gender identity for all Title IX purposes. But the American public pushed back hard. The department received over 200,000 public comments to that proposed rule, which is more than any comments on any proposed rule in the history of the Department of Education. The US chapter of WDI provided a template for our signatories and supporters to use in submitting comments, as did the radical feminist organization, Women's Liberation Front. By May 2023, the Department of Education had changed its tune. That month, it issued a new proposed rule that appears to have scrapped the idea of redefining sex out of existence. The new proposed rule would allow gender identity to override sex in certain cases, which is bad. But the department appears to have walked back the idea of completely getting rid of the material reality of sex. Whatever Biden might be saying publicly, his own Department of Education is getting the point that Americans don't like what he's doing with respect to gender identity. I count that as a win for women and girls. Can I have the next slide, please? There's one additional item with respect to the administration that I think is significant. In January 2022, the US Bureau of Prisons, which is part of the Department of Justice, updated its transgender offender manual. This is the policy guiding which male prisoners in federal prisons will get to be housed in the women's prison on the basis of their claimed woman identities. This was a full year after Biden issued Executive Order 13988. The Bureau of Prisons had a full year to figure out how to let male prisoners completely self-ID into the federal women's prison. It didn't do that. To be clear, the so-called transgender offender manual isn't good because it allows some men to be housed with women on the basis of their claimed woman identities. But it does so on a case-by-case basis. We should, of course, oppose this, and we do. But the fact that the Bureau of Prisons came out with a new policy a full year after the Biden executive order declining to completely redefine sex to include gender identity, even though that's exactly what the executive order told it to do, strikes me as significant. Okay, on to Congress. Can I have the next slide, please? The main thing to focus on with respect to Congress here is the Equality Act, also known as the bane of feminists' existence since 2015. I need to say at the outset that this bill is not like other legislation that exists in other countries that enshrines some form of gender in the law. For example, the UK Equality Act protects gender reassignment as a category, but it also protects sex as a distinct category. I understand that there has been some debate of late about what the word sex means in the UK Equality Act. But my point here is just to acknowledge that sex, however defined, exists as a standalone category in the UK. My understanding is that Canada does something similar. I don't like it that any of these laws protect gender in any of its forms. But this US bill, if enacted, would completely redefine sex out of existence for literally all purposes under US civil rights law, including education, housing, and public accommodations, including things like toilets and changing rooms. In my view, protecting gender as a category while also protecting sex as a category is bad, but it's slightly less bad than redefining sex out of existence, which is what the US bill would do, which would be a complete disaster for women and girls. Another thing to know about this bill is that as bad as Biden's executive order is, this bill is much worse because it reaches much farther. The president has limited authority under the US Constitution, and his order only reaches federal administrative agencies. Congress, on the other hand, has the authority to do much more damage. This is how Congress summarizes the bill. The bill prohibits discrimination based on sex, sexual orientation, and gender identity in areas including public accommodations and facilities, education, federal funding, employment, housing, credit, and the jury system. Specifically, the bill defines and includes sex, sexual orientation, and gender identity among the prohibited categories of discrimination or segregation. The bill allows the Department of Justice to intervene in equal protection actions in federal court on account of sexual orientation or gender identity. The bill prohibits an individual from being denied access to a shared facility, including a restroom, a locker room, and a dressing room that is in accordance with the individual's gender identity. Can I have the next slide, please? This is how the bill defines gender identity. The term gender identity means the gender-related identity, appearance, mannerisms, or other gender-related characteristics of an individual, regardless of the individual's designated sex at birth. Now, I will leave that here for now, because all we really need to know about the bill itself for the present discussion is that it would obliterate women and girls as a sex class all over the US and for virtually all purposes. It's that bad. What I really want to focus on here, though, is the politics surrounding the enactment of the bill, or rather, Congress's failure to enact it and all the work that the US chapter of WDI has done to stop it. Can I have the next slide, please? Okay, this guy is named Charles Schumer. He's the majority leader of the US Senate, making him the most powerful member of Congress. I would actually argue that he is the most powerful person in the US government because Congress has much more authority than the president by constitutional design. So even though many people have never seen or heard of him, this is the guy calling the shots, and he's a Democrat. As mentioned, this bill has been around since 2015. It has passed in the House of Representatives twice. It has never gotten to a vote before the full Senate. It most recently passed in the Democrat-controlled House of Representatives in February 2021. When that happened, it is not an exaggeration to say that US feminists went into a near panic. President Biden had vowed to get the bill passed within 100 days of taking office, and we were very worried that he would succeed. At that time, both chambers of Congress were controlled by Democrats. The bill very quickly went to the Senate, and it was scheduled to be heard before the Senate Judiciary Committee in March. We quickly took action. The US chapter of WDI had several meetings with a senior staffer in Schumer's office. She seemed to be somewhat sympathetic to our arguments. We then submitted written testimony before the hearing was to take place. In our testimony, we made three basic arguments. One, the nation hasn't had the conversation we need to have before enacting this legislation. 2, men aren't women, even if they say they are. And 3, children are being harmed at the altar of gender identity. I submitted that testimony via email, and I received written confirmation that it was received by every member of the committee. WDI USA also sent a separate letter to Majority Leader Schumer. That letter had been circulated by WDI globally, and it was signed by thousands of women all over the world. We're deeply grateful to WDI International for circulating the letter and to all the women who signed it. The bill passed in the Senate Judiciary Committee in March. From there, it should have gone to the full Senate for a vote, but then something interesting happened. Nothing. That was March of 2021. 100 days from Biden taking office would have been sometime in late April or early May of 2021. Majority Leader Schumer had the authority and plenty of time to bring the bill before the full Senate for a vote at any time after it passed in the Senate Judiciary Committee, and the bill most likely would have sailed through. He didn't do it. Not only did the bill not pass within the first 100 days of Biden taking office, it didn't pass at all in 2021. We kept the pressure on. In January 2022, thanks to a very generous donor, we sent a copy of my book, The Abolition of Sex, to every member of the US Congress. Excuse me. We also developed an alternative to the Equality Act, which we called the Equality for All Act. The primary author of that bill was US country contact Carrie Bruss. That bill had initially been drafted in 2020, and we decided to deploy it in 2022. The bill would protect women and girls on the basis of sex, lesbians, gay men, and bisexual people on the basis of sexual orientation, and everyone on the basis of nonconformity with sex stereotypes. Every month throughout 2022, we encouraged US signatories to send a copy of the bill to their House members and senators. As 2022 wore on, we became a bit mystified that Schumer wasn't taking action on the Equality Act. And by the end of 2022, the bill appeared to be dead. So what happened? You may remember that I referenced the Department of Education's 2022 proposal to redefine sex out of existence for Title IX purposes. The very last day to comment on that proposal was September 12th, 2022. On that day, a group of Senate Democrats sent a letter to the Department of Education praising their proposal to redefine sex out of existence. There's nothing unusual about that. But what was unusual was that that letter was signed by 19 Senate Democrats. There are 50 Democrats in the United States Senate. If 19 of them signed that letter, that means that 31 didn't. By September 22, in other words, fewer than half of US Senate Democrats were willing to put their names on a letter encouraging the Department of Education to redefine sex out of existence. What might that also say about their views of the Equality Act? And did our relentless advocacy throughout 2021 and 2022 have anything to do with it? What's more, the US Senate did pass a different bill in November 2022. It's called the Respect for Marriage Act, and it protects the legal marriages of same-sex couples. 12 Senate Republicans signed that bill, among them some of the most conservative Republicans in the country. So my question is this: if Majority Leader Schumer could get so many senators to support marriage equality, why couldn't he get similar Senate support for gender identity? Earlier this year, we declared the Equality Act to be dead. In doing so, we said that we're not out of the woods yet because a member of Congress could bring it back. But we said we didn't think that would happen because we didn't think the Democrats in Congress were stupid enough to do that. The death of the Equality Act in 2022 should have been a major embarrassment for the president, who had promised to get it passed within 100 years of taking office, and not only failed to do that, but then failed to get it passed within 2 years of taking office. Well, it turns out that we were wrong, and some Democrats are stupid enough to bring the bill back. It came back this past month, but interestingly, it only had 4 sponsors, and Majority Leader Schumer hasn't said a word of support for it. I was recently talking with a friend who knows a lot about the inner workings of Congress. She agrees that the Democrats are idiots for bringing this bill back and that it has no chance of going anywhere. It won't get a hearing in the House of Representatives because that body is now run by Republicans. She also thinks the Democrats aren't quite stupid enough to bring it to a hearing in the Senate. Having embarrassed the president once by failing to get this bill passed during the first 2 years of his administration, they probably aren't stupid enough to do it again. But who knows? I'm meeting this coming Friday with some friends about how to get me a shot at testifying against the bill if it does get a hearing. That referred to this past Friday, and I can update everyone during the discussion. I hope this bill does not get a hearing because I want it to die a final death. But on the other hand, I hope it does get a hearing because I would relish the opportunity to tell the Democrats in Congress, my party leadership, exactly what I think of their stupid bill, live and on camera. In sum, the president likes to blather on about getting the Equality Act passed in his State of the Union addresses and elsewhere. But the president likes to blather on about lots of things. Regardless of what he is saying in public, the situation looks very different on the ground. One last thing about the Equality Act before going on. One reason it is so astonishing that this bill hasn't passed in 8 years is because of the support behind it. Can I have the next slide, please? This bill has the strong support of not only the Human Rights Campaign, but also of HRC's coalition of more than 500 major corporations. HRC put this coalition together for the specific purpose of getting this bill passed. I've skimmed the list of corporations involved. They include some of the richest and most powerful corporations in the world, including Amazon, Apple, Bank of America, Capital One, and Comcast. This is what we've been up against the entire time. We, radical feminists, volunteers, poorly funded, with no political power and no public face whatsoever, have been up against some of the richest and most powerful institutions in society. And somehow, miraculously, we're not dead yet. Okay, on to the judiciary. Can I have the next slide, please? As mentioned, the Supreme Court decided Bostock versus Clayton County in 2020, and the Biden administration has been using it to shred women's rights since taking office in 2021, with a slew of executive orders, memos, and guidance documents that tell federal agencies to redefine sex to include gender identity for nearly all purposes under federal administrative law. I'm happy to report, though, that Biden's efforts to shred women's rights aren't going very well for him in the US courts. In 2022, a federal court in Tennessee said that all of the orders, memos, and guidance documents were invalid because the administration had failed to follow applicable procedural law and blocked them from taking effect in 20 states. That's good, and the matter is currently on appeal. The US chapter of WDI had filed a friend of the court brief in the district court in that case, and Women's Liberation Front filed a friend of the court brief on appeal. This year, a federal court in Texas ruled that one particular Biden memo was substantively flawed as well. One of the Biden memos concerned the Affordable Care Act, and it said that medical practitioners who receive federal funding under the act aren't allowed to discriminate against people on the basis of their gender identities. In this case, a doctor had a male patient, and the doctor was concerned that his male patient might have prostate cancer. He wanted to refer the male patient to prostate cancer testing, but the male patient said, essentially, I identify as a woman, therefore I do not have a prostate, therefore I cannot have prostate cancer. literally. The doctor received federal funding under the Affordable Care Act, so he was worried that referring the man for prostate cancer testing might constitute unlawful gender identity discrimination, so he was unable to provide proper medical treatment to his patient. So he and some other doctors challenged the Biden administration's guidance on this. The court agreed, ruling that sex means sex under the Affordable Care Act, and that doctors can provide sex-appropriate treatment. That's good, but there's a reason it's even better, which is that the Affordable Care Act defines sex by reference to Title IX. That means that this court also ruled that sex means sex under Title IX, which is great. That matter is also on appeal, and we have filed a friend of the court brief in that court too. There are a few other recent cases worth mentioning, even though they don't involve the Biden administration. In one, a panel of the Ninth Circuit Court of Appeals ruled that a beauty pageant that limits participation to women is allowed to exclude men, including men who claim to have woman identities. Probably no one here tonight likes beauty pageants. I know that I don't, but that's not the point here. The point here is that this is a strong indication that women's organizations may legally exclude men, including men who claim to have woman identities. Women's Liberation Front had filed a friend of the court brief in that case, and Wolf's brief was cited in the court's opinion, which is pretty astonishing. To the best of my knowledge, it's the only time in recent history an amicus brief filed by a radical feminist organization has been cited in a federal court opinion, and it's a big deal. In another case, the 11th Circuit Court of Appeals ruled that schools are allowed to maintain single-sex bathrooms. That's really good and quite sensible. But what's really amazing about that case is that the losing party, a woman who wanted to use the men's bathroom on the basis of her claimed man identity, was represented by Lambda Legal. This is an organization that is so corrupted by gender identity that it may as well be the ACLU. Lambda Legal chose not to petition the Supreme Court to review the decision, which is huge because it suggests that Lambda Legal knows it's losing. The Women's Liberation Front had filed a friend of the court brief in that case back in 2018, which I had the honor of working with my colleagues then at Wolf on. Finally, there's a case pending before the 4th Circuit Court of Appeals where a lower court has ruled that states are allowed to maintain single-sex sports. Our chapter has filed a court brief pending there too. The thing that's most astonishing about that case is that the lower court ruling was made by a judge who had been appointed by President Clinton. Now, we can all think whatever we want about President Clinton, but the point here is that to the best of my knowledge, this is the only legal ruling entered by a Democrat-appointed judge that preserves the material reality of sex in a way that benefits women and girls. Okay, the only thing left to say here is that we're making strides in the states too. Thanks so much to the volunteer women who make up our state legislative action team, we have submitted countless pieces of written testimony in support of bills to protect women and girls as a sex class, in support of abortion rights, and in opposition to efforts to erase women and girls and/or to harm children. Over the past couple of years, our team has become extremely organized, focused, and fast about analyzing bills, figuring out our positions on them, and writing and submitting testimony. And I'm very happy to report that there are increasing numbers of Democrats who are voting in alignment with the principles of the Declaration on Women's Sex-Based Rights at the state level. Can I have the next slide, please? Although it may not be obvious, we have made huge strides. The Biden administration has so far been unable to persuade either Congress or the courts that it's a good idea to throw women and girls under the bus at the altar of gender identity. And we think that the US chapter of WDI has had a lot to do with that. America is waking up to the horrors of gender identity, and they're not having it. Okay, I will end there, and I'm happy to explain anything left unclear or answer questions. I'd like to and at the top of the hour to respect everyone's time. So feel free to put, there's no questions in Q&A right now. Feel free to put them in there if you'd like, or feel free to put questions in chat. Vajra is asking in chat about adding the breakthrough into the media, meaning my appearance on Dr. Phil. Yeah, I mean, I got invited in July of 2022 via email to have a conversation about possibly appearing on the Dr. Phil show. And over the course of the next few months, I had a couple conversations with the producers of that show. And they didn't really waver in their commitment to having me on the show, which was good. And at one point, it was really funny because I was on the phone with one of the producers and she said, Kara, it has been remarkably difficult to get someone to come on the show to debate you. And I thought that was kind of hilarious. Ultimately, they did. They found this man who appeared on the show wearing a very flowery dress and a large wig and a lot of makeup. And we did the show. Also present during the show was Ruth Barrett, who published, having edited a very important book called Female Erasure. I believe that was published back in 2016. Ruth appeared via Zoom. And I would like to think that Ruth and I did a pretty good job of exposing the lies of gender identity. The man in the dress he was very aggressive and he kept pointing at me, and he complained that I insisted on talking about reality, and he put reality in quotes, which is kind of funny. There was also a woman there who calls herself a non-binary dad. She had recently given birth to a child, and she considers herself male. And as far as I could tell, she's on testosterone. She has a beard. I have grave concerns about that woman's child and her child's well-being. I don't know anything about it, but I think Ruth and I did a pretty good job of exposing the lies of gender identity. At least I'd like to think so. Okay, I'm seeing some questions in Q&A. What are some things that WDI has done for California laws that are undermining parental rights? I mean, this is such a good question. California has just been absolutely vicious in shredding the rights of children not to be harmed by so-called gender identity, the rights of female inmates to be protected against having to share locked prison cells with male inmates, and against the rights of parents who have sincere and genuine concerns about their children who are being indoctrinated in schools and taught they might have gender identities. So the state legislative action team would be a great entity to ask about what the state legislative action team has had to say about California's proposals to shred the rights of women and girls, children in general, and parents. I know that WDI recently had a call-in action concerning one bill in California. I don't know if that bill was particularly a parents' rights bill, but I know that we did do a call-in action because there was just too fast of a turnaround to be able to submit written testimony. But if you are a California resident and you want to get involved, please do get involved and join the state legislative action team. I'm sure the team can use all the help that it can get, especially in California. Question, what do I think of the bans being overturned in regard to gender affirming care of minors? I think a lot about these things. There's recently a case called LW versus Skermetti that came out of the Sixth Circuit. This is a really interesting case where the state of Tennessee had enacted a law that bans so-called gender affirming care, by which it means puberty blockers, wrong sex hormones, and surgeries on minors. And a group of kids who think they're trans and their parents and doctors sued the state. And the case went before a federal district court, which ruled in favor of the kids' parents and doctors. And what the court did was impose a statewide injunction, meaning the court blocked the state law from taking effect. And the state filed an emergency appeal and a request for a stay on that. Now, what that means, and they got it. So what that means is the state said, we need to be able to enforce this law, which is designed to protect children. And the Court of Appeals, which is the Sixth Circuit, agreed with them, which I think is hugely significant. I've been doing a lot of thinking about what the ruling means. One thing that I think is hugely significant is that this particular Court of Appeals seems to be assuming that so-called puberty blockers and wrong sex hormones are both irreversible and experimental. I think that's a big development, because one of the arguments that the gender identity industry often puts forth is that puberty blockers and opposite sex hormones are neither experimental nor irreversible. And for the court to assume that they are, I think I just misspoke. I think the gender identity industry acknowledges that wrong sex hormones are irreversible because they have to. But my point here is to say that for the court to acknowledge that puberty blockers and wrong sex hormones are both experimental and irreversible strikes me as a major development. So that the latest outcome in that case was just this past Saturday, and I'm watching it very closely, and we'll continue to do so. Patricia asks, what about California? We have a nest of wokeness that is overriding women's rights. Our governor is fine with men pretending to be women into prisons, for example, and our schools in San Francisco push gender identity. I could not agree with you more, Patricia. California is in many ways ground zero for all of this, and it's absolutely horrible. You're right, your governor is fine with men pretending to be women in women's prisons. Probably most participants of this webinar know there's a man named Scott Wiener who serves on the state Senate. He's largely responsible for most of this legislation, which shreds the rights of women and girls, shreds the rights of children to be protected from harm, and shreds the rights of parents to be involved in their children's medical decisions. Senator Wiener has also introduced, and I believe gotten passed, a whole host of other horrific legislation that puts children in positions of being vulnerable to being sex trafficked throughout the state. Abigail Schreier has an article from maybe 4 or 5 months ago, basically accusing Scott Wiener of turning San Francisco into a safe haven for sex trafficking of minors. And it's absolutely dreadful what's happening in California. Sarah says, how about tackling local city so-called human rights laws that have recently snuck in the term gender identity into the local laws that allows males to enter women's locker rooms, like here in New York, and the recent case in Seattle, Washington, where the Korean-run women's spa were ruled to have to allow males into the all-nude women-only spa. So the Washington case is an important case and an important one to watch. I mean, I do have to say that I'm not sure that the Washington Human Rights Commission was legally wrong to order the spa to allow the men into the women's spa. And I say that because, of course, I think that's totally morally wrong, repugnant, and antithetical to women's sex-based rights. But Washington state law on this topic is not that much less dreadful than California's. And I hope the spa continues to fight. My understanding is that it will, and I hope it wins. I hope it gets a say in district court. And I hope it rules that allowing men to be able to access women-only spaces is itself a form of sex discrimination. I think we have to get there. We have to get the courts to listen to those kinds of arguments. As for local advocacy, please, please, please do. WDI US chapter just simply does not have the resources to get involved at the local level. I wish we did. We're heavily involved at the federal level in all 3 branches of government, as I was just explaining, and our state legislative action team works tirelessly to get involved at the state level. We just don't have the resources to get involved locally. But the question, Sarah, is absolutely right. These things are so important at the local level. Please, everyone get involved locally. Contact your school boards, contact your supervisors, your board of supervisors, your city government, your mayor, your city councils. Please get involved as much as you possibly can at the local level, because the US chapter of WDI just doesn't have the resources to do it. Okay, Olivia says she lives in Oregon, joined a gym, asked the gym if men were allowed, and was told that yes, the gym was forced to allow this man to use the space because the man involved a lawyer and forced the issue. How to begin to combat that The gym has 4 single locker rooms. This man refuses to use them. So I really want women to start suing these businesses, spas, etc., gyms with locker rooms, arguing sex discrimination. And the real challenge here is that Oregon law says whatever it says, and Washington law says whatever it says, and California law says whatever it says. There's no national standard governing all of this other than the Equality Act. If it passed, that would be a blanket law all over the United States that every place of public accommodation, which includes every spa and every gym and every movie theater and every restaurant and every bar, would have to allow men to access women-only spaces. And to the extent that we can do it at the local and state levels, I'd love to see women file lawsuits challenging these things and saying explicitly that allowing men into women-only spaces is itself a form of discrimination against women and girls. Chris says Tony Thurston is also doing horrible things with the education department. I'm not sure, Chris, if that refers to California State Education Department or the federal education department. Feel free to clarify. Lois, have you looked into getting onto the Bill Maher show? He's very supportive of sex-based rights. Lois, don't get me started. The answer, of course, is yes. I would love to get onto the Bill Maher show. I am in contact with the producer who books his DC-based guests, and she has assured me that she will get me on the Bill Maher show. That was maybe 6 months ago, and I haven't heard back. So we'll continue in that. Question about California. Okay, so Adrian is talking about joining Our Duty in California. Please do that. If you're in California, please do join Our Duty. It's a great group. My understanding is it focuses mostly on parental rights, but it's also very critical of all the many ways in which California is shredding the sex-based rights of women and girls, the rights of children to be free from harm, and the rights of parents. My understanding is that Our Duty is doing really, really fabulous work in California. So that's a really good idea. Kara says Congressman Dan Goldman is very aggressive in his fealty to gender ideology, especially with respect to children and schools. She's written to him and gotten back boilerplate BS in lieu of a direct response. Any information about him or what can be done about him? I don't know about Congressman Dan Goldman, but I can say this. I hear from people every day who write to their representatives and senators, and they say, I have grave concerns about what this is doing to women and to children. And what the Democrats will write back is, as Kara says, it's BS, but they'll write back, I stand in support of the LGBTQIA community. That's what they hide behind. And I'm happy to say that the Lesbian Caucus of Women's Declaration International USA is doing some really good work and writing some really important stuff about the importance of stopping this forced teaming of lesbians, gay men, and bisexual people with the rest of the alphabet. It's really critical. And I just think that the forced teaming of the T and now the TQIA+++ with lesbians, gays, and bisexuals was a political stroke of genius on their part. And I'm just really proud to see the Lesbian Caucus of WDI USA take a stand and say, no, we are lesbians. We do not wish to be forced teamed with any other category. And we're going to keep fighting for our rights as lesbians. But so to the extent that you can, if you support the rights of same-sex attracted people and your representative gets back to you with some nonsense about LGBTQIA++, write them back and quote the Lesbian Caucus of WDI USA. The Lesbian Caucus has some great statements up on our blog. Quote them extensively about the importance of not forced teaming lesbians with the rest of the alphabet. Thank you for the question. Question from Elizabeth. What do I think progressive leaning voters don't realize? Oh, sorry. Why do I think progressive leaning voters don't realize Dobbs is an almost identical attack on female sex as transgender identity and ideology that relies on misogyny? It's an interesting question. So Elizabeth is referring to Dobbs, which is the Supreme Court case that reversed Roe v. Wade last year. Why do I think progressives don't see that it's the same? It's very complicated, but the gender identity industry will argue that it's important for people to have abortion rights, just as it's important for people to have gender affirming care, because all of that comes down to a matter of bodily autonomy. I think it's very important for feminists, including WDI, to emphasize that our interest in abortion rights stems from our commitment to the liberation of women. We think that women ought to be able to make their own healthcare decisions on the basis that women are actual full human beings. We are autonomous human beings. And if that were understood, then we wouldn't be having this problem with abortion rights. But by framing abortion as a matter of equality, I think that the abortion rights movement has largely done a disservice to women. We have to be able to name ourselves as a sex class, women and girls as the sex class known as women and girls, also known as human females, if we are to meaningfully fight to our right to reproductive health care and our right to female-only spaces. Beyond that, I'm not entirely sure why progressives can't see it, other than they're just blinded by the media. The media just lies to progressives all the time. Have I connected with Foundation Against Intolerance and Racism? Yes, they published me today. I'm so excited. They republished a piece that I had previously published at the Washington Examiner, and it's called "What is a TERF and Why It Matters in Today's Political Environment." And I'm closely connected with their leadership, and I hope they'll publish more from radical feminists. They have local chapters that may be helpful. Thank you. Yeah, I did a little bit of reading up on FAIR today, and so I understand they have local chapters. Thank you for that. Okay, I just need to say that the chat is moving so quickly and the Q&A is moving very quickly as well. I'm sorry if I can't get to everything. Nancy asks, is there a way we can expose which newspapers use which trans editorial style guides to self-censor their content? I think this is huge. The Trans Journalists Association style guide tells journalists not to platform rad femmes, families of trans identifying kids, detransitioners, or so-called true scum, i.e. trans identified people who believe, who stand up for the reality of sex. This is a huge issue. I just came across this organization, the Trans Journalists Association. I haven't had a chance to read what they write. I'm very worried about them. I do know that the vast majority of media outlets across the United States, including conservative media outlets, follow the Associated Press style guide, which recommends all sorts of language that obscures the material reality of sex. I'm no longer surprised when outlets like Washington Post and New York Times do it. They've been doing it for years. It is extremely frustrating to me when outlets like the Washington Examiner, the New York Post, and Fox News cave as well, which they do frequently. Gary asks, what rights do we have speaking up at our jobs? I can't answer that because I can't give you legal advice. All I can say is please, please, please push back as hard as you can. If your job wants you to put your preferred pronouns in your email signature, I'm sorry, I cannot give you legal advice because employment discrimination is not my area of expertise, and also because there might be different laws in place in different states and localities. Okay. Oh, there's a lot there in Q&A. Thank you, Kara, for complimenting my piece on FAIR. I think that might be all that I have time to get to. I'm going to close the Q&A because it's just moving faster than I can monitor it. Okay, so the last question I will answer is Lois asking about gender ID being sex discrimination against women. Please explain. So for example, I was once in a restaurant in Washington, DC, and there was a man who at first just like approached me in a really uncomfortable way. He was like right up in my personal space. It really bothered me. And as I turned, and he got his drink and went to his table, and I looked, and he was wearing a long flowy dress, and he had pink toenail polish and had a long blonde wig and was wearing lots of makeup. And he had all these tote bags with him, very flowery tote bags. And I went into the women's bathroom, and I very quickly saw that in the stall on the floor were all the tote bags and the feet with the pink nail polish. And my initial thought was just to get out of there, which I did. And I spoke with the owner of the restaurant, who I happen to know, and it's a very family-friendly place. And he had his 3 minor daughter there at the time, and he was no more happy about the situation than I was. And we dealt with it, and we moved on. And this was a couple of years ago. But I've been thinking more recently about state and local laws that list categories of discrimination. And I happen to know that Washington, D.C. protects sex as an independent category. It also protects gender identity, which I don't like, but it does protect sex in public accommodations. And I wouldn't want to sue this particular establishment because the owner of the establishment was totally on my side with it, and I wouldn't want to do that to him. But should something like this happen again, I would seriously consider filing a complaint with the DC Human Rights Commission, arguing that allowing this man into the women's restroom on the basis of his so-called gender identity constitutes sex discrimination, and therefore discrimination against women and girls. And I would encourage women all over the country to look into your local laws, look into your state laws, find the places where sex is protected as a discrete category, and find ways of complaining to your state and local human rights commissions, whatever they're called. Submit a complaint. These bodies exist for a reason. And where you can say that having this man in a space that is designed for women and girls constitutes unlawful sex discrimination against women and girls in violation of state and local law. And with that, I think we have to conclude. We're at the top of the hour. I've done my best to cover the questions that came up, and I covered, I think, as many as I possibly could. Lorraine, do you have any concluding remarks?
It was just a great webinar, and I just want to say thank you to the teachers who are fighting back. That is so needed. Thank you.
Absolutely. Thank you, everyone. Have a great rest of your night, and look out for the recording of this video, which will be on the YouTube channel of Women's Declaration International US chapter. Thanks, everyone. Have a great night.